Hi, I'm Glenford Jameson. I'm a Canadian food lawyer and principal of Jameson Company. I'm really excited to speak with you today about updates in Canadian food law and regulatory law in relation to food and trade in Canada over 2021 up until this point. I did a video like this in 2020, which you can check out on YouTube, but there's been quite a bit that's changed around the world, and I mean, that should be surprising to no one. It also affects our food law and regulation, particularly in Canada. We have a significant agenda today we want to get to. I'd like to go over sort of the basic components of food regulation in Canada, talk about our regulator and our legal framework. After that, I would like to go through some food labeling and nutrition discussions. We're going to talk about food additives and fortifications, plant-based proteins, advertising to children, which is an important piece right now. And we're going to do a small update on EU-Canada trade relations, which has an impact on food. So the first question obviously is, who am I? So my name is Glenford Jameson. I've been running a firm that's dedicated to food regulation for 8 years now. We're a small team, and we're the only team in Canada dedicated to food law. That's all we do as a firm. That food law question of like, what is food law for us? It means two separate things. Half of what we do is food regulatory work, and half of that is on the front end of issues, dealing with food additive submissions, dealing with natural health products, approving claims, seeking pre-clearance of certain issues, marketing claims, those sorts of things, dealing with novel foods, pre-market safety assessments, and that's a really engaging and invigorating part of our work. On the back end, we deal with a lot of enforcement issues. Trade complaints, competitor and customer complaints, food sickness issues, recalls, working with the Public Health Agency of Canada, or CFIA, dealing with items that are detained or seized at the border, and managing recalls across Canada. Those are really important issues, and genuinely, in 2021, as we've got further into the new framework for food, the Safe Food for Canadians Act and regulations, we're seeing more and more trade complaints and more items held up at the border as we're learning what those things mean, and as competitors to other entities in the food sector are finding that there's been an uneven application to those rules as they're being implemented. Maybe they were the first to fall, and so their response has been to try and police the market themselves. And so we've certainly seen an uptick in that. So that's a big chunk of what we do as well. On the other half, we do corporate commercial work. And that corporate commercial work really relates to bringing that food law expertise into commercial agreements. Often it's about setting up an agreement to manage a distributor relationship, or an importer or broker issue, or a brand license, or certain intellectual property issues. We have a really strong network in Canada of experts in virtually every area of law that you could want. And so for things that we don't necessarily do, we can usually find a very good employment or labor lawyer who has expertise in the food sector, if that's a concern. Or if you need a trademark or patent lawyer in Canada who has expertise with food, we've got those as well. And so when we're working, we find that we really delve into an informal network of lawyers who are really extraordinary talents. And all that to say, it's been a fun 8 years, and I'm really pleased to be here today to speak with you and share with you what's happening in Canada. So in Canada, there are a variety of things that are federal jurisdiction, and there are those things that are a provincial jurisdiction. Of primary interest to international stakeholders in our food channels is that anything that crosses borders, be it federal or provincial, falls under an interprovincial trade or international trade component of our division of powers, which means that automatically federal regulators and federal legal frameworks apply. On top of that, it's really important to know that in Canada, our Constitution sets the criminal law power at the federal level as well. So unlike other jurisdictions where, say in the US, certain crimes are state by state, in Canada we have the criminal code that is the Canadian Criminal Code. And for the purposes of our criminal law, without getting too nerdy about this, Health and safety and welfare legislation has been, as it relates to food, has been captured as a criminal law power. So 100 years ago, there was a case about sausages being sold in Vancouver, and the question was, can federal regulations manage or oversee or have jurisdiction over if someone's making a sausage, what actually goes into it if it's marketed as sausage? And our courts said that yes, if this relates to food safety and not to commerce or civil rights or contract, then our federal rules do apply. And so a good thing to keep in mind for our international stakeholders is that you're almost always dealing with a federal framework. You're dealing with a federal regulator, the CFIA, and you're dealing with the Public Health Agency of Canada if you've got a public health issue, and you're dealing with Health Canada. And when you get into the provinces, if you're not dealing with interprovincial international trade, then you may be dealing with provincial authorities, public health units, Ontarian or British Columbia Health Protection and Promotion Acts, like these sorts of things, that have their own food safety guidelines and their own food safety regulation. But typically speaking, the big dog in Canada is a single regulator, and that is the CFIA. Now at the federal level, we're really looking at and interested in two separate frameworks, typically when dealing with food and the importation of food into Canada and the marketing of it, frankly. One is an old statute that goes back about 100 years in Canada, the Food and Drugs Act and the Food and Drug Regulations, which are hundreds of pages long, and set out standards of identity and set out base rules around nutrition labeling and import and food safety and additives and a variety of other things, including drugs and natural health products. And the second is a very new statute that was passed in 2012, but really wasn't brought into force until 2019, and broadly hasn't been in force for more than a year. It's since July 2020, I believe, was when it started to apply to all goods, and is still sort of just reaching its total effect in terms of the obligations that the Safe Food for Canadians Act and the regulations to it put on importers, distributors, manufacturers, international stakeholders. Now that act is different than the Food and Drugs Act. The Food and Drugs Act primarily relates to food safety at its core, although a large chunk of it does relate to trade and commerce by creating standards of identity. The Safe Food for Canadians Act really relates to trade and to nomenclature, and food safety is a core part of it, but on a constitutional level, unless you're crossing borders with whatever, with your goods to bring them to market, then the Safe Food for Canadians Act doesn't apply. So if you are a cheesemaker in Prince Edward Island and you're taking your goods from Summerside to Charlottetown, then you don't need to worry about the Safe Food for Canadians Act. But if you're a cheesemaker in Parma and you're seeking to market your goods in Toronto, then it is a concern, and those rules should apply to you on a very high level. Those are the two primary legislative frameworks that we have to deal with. Obviously, at the trade level, there are a variety of other pieces at the federal level. There are tariffs and sort of the Customs Act and sort of assessing the dollars and cents of things. But what we find as food lawyers is usually our clients have a fairly good handle on those issues on the front end, at least. And sometimes we get into a tariff determination discussion, but generally speaking, those are things that you can sort of sort out yourself. The real complication is in this new act and framework. Again, the Safe Food for Canadians Act is very new, and we're just now seeing how things are moving and being implemented, and how the CFIA, the Canadian Food Inspection Agency, is implementing its new powers. There are other bodies to be aware of. Chief among them is Health Canada. Health Canada sets out food policy generally, certainly as it faces Canadians, right, as a matter of public health. There's Public Health Agency of Canada as well, which sort of lives in or amongst Health Canada, and they don't have a lot of power on their own, but they can inform how regulatory enforcement occurs either at the CFIA level or at Health Canada's level. And Health Canada has its own regulatory enforcement group, as well as CFIA, which primarily engages in regulatory enforcement, inspections, and those sorts of things. CFIA also oversees agriculture in Canada, and so another ministry to be aware of or organization is Agri-Food and Agriculture Canada, and they have a variety of oversight over seeds and feeds, fertilizers, a variety of things that are relevant to protecting Canada's food supply, which often can be an issue with importers who are bringing in foods that can contain known pathogens that could be an issue in our food chain. So when you're dealing with seeds, when you're dealing with meats that could contain prions, for example, those are things that are policed, but they're policed more from the agricultural level than from the food level. However, you're dealing with the same regulator. You're dealing with the Canadian Food Inspection Agency. Another example would be there are significant prohibitions relating to import and trade for things that might carry hoof and mouth disease, those sorts of things. Other agencies to be aware of, as we like to say here, the Queen always gets her money, so the Canada Revenue Agency is important. They work hand in hand with the Canada Border Services Agency, which is sort of the first point of contact at the border. Additionally, we've got the Competition Bureau, which can oversee any number of things that it deems anti-competitive. In the US, we call it antitrust. In Canada, it's competition law. And so often when things are marketed in a way that is counter to our competition laws, then that can be an issue, although they generally cede their powers to the CFIA. And then there are a number of other agencies which you can see here on the slide that you may engage with, depending on the products that you're bringing in and the issues that you may have with them. Because the Food and Drugs Act is pretty well-trod territory, I'd really like to focus in on the Safe Food for Canadians Act, which is certainly a place where I'm spending a lot of time if not relitigating, then certainly questioning or looking for points of authority on how to manage some trite and some new and complex areas relating to food production, specifically for meats and some cheeses, as well as just simple trade issues. It's really hard to overstate how big of a sea change this act is. And for those of you who are used to doing work with the United States and who have been sort of broken in, let's say, by FSMA, this is Canadian FSMA in some ways. And so it's really hard to overstate suddenly how much documentary obligations distributors in Canada or importers of products have in terms of the food safety elements and the HACCP codes and how pathogens are dealt with, as well as base things like labels and ensuring that claims are compliant, and traceability. Here on the slide, you've got a general statement of sort of the function of the SFCA, as we call it, which is, it's an act, and again, it's hard to overstate how broad and impactful this is. An act respecting food commodities, including their inspection, their safety, their labeling and advertising, their import, export, and interprovincial trade, the establishment of standards for them, the registration or licensing of persons who perform certain activities related to them, the establishment of standards governing establishments where those activities are performed, and the registration of establishments where those activities are performed. This is not only something that governs imports and exports, it creates an entire licensing framework, which has a ton of positive obligations on everyone in the food system. If you are frustrated with your Canadian domestic distributor because they are asking you for a lot of information in relation to product formulation, HACCP, your BRC certification, your IFS global food certs, a general HACCP plan, authorizations from your national health or food ministry. This is why. And so a year ago, it was apparent that this was going to be a large change for us. Now, having really worked in this in a year, when it's actually applied not just to meat, but it's applied to most products that cross borders, It's been a very interesting time to see how CFIA is using those powers, what their expectations are for documentary requirements for Canadian food businesses that engage with international stakeholders for importation. So hold on, and then there's lots more to come. Now, there are some really great things to come out of this act. As a member of the Canadian public who eats a lot of Canadian and imported foods, having standards is a big deal. It's really critical. Having a licensing framework brings all actors out of the dark and forces them to be on a registry in a place where we can find them. And so in the context of a pathogen outbreak, CFIA suddenly has a complete constellation, or at least a complete guide to the galaxy, and they can find the constellation where pathogens may exist. In Canada in 2007, and then again in 2012, we had two very different pathogen outbreaks relating to meats and processed meats. And they took longer than they should have to find the culprit. And people died, and a class action resulted from it, and it was very sad. And so what informs this act is certainly those two large events in finding that the existing regulatory framework under the Food and Drugs Act, and then what we used to have, which was a variety of regulations and acts relating to agricultural products and relating to consumer packaging and labeling and those sorts of things, wasn't satisfactory. And so putting everything together in one place really allowed CFIA, or would allow CFIA, to better able exercise their authority and protect Canadians from significant outbreak. What that looks like for licensed parties, and licensed parties are typically those who bring food across borders, or certain foods across borders, to market in various provinces in Canada, so import or export. What it means for them is it means that there are significant documentary requirements that you're expected to uphold. Traceability documents, 2 steps forward, 2 steps back, in a way that's acceptable to CFIA. You are expected to have a preventative control plan, PCP, which is similar to a HACCP plan, and is something that can be reviewed under inspection, which will happen and ideally improved upon on a regular basis. Something that's really positive for industry is prior to the Safe Food for Canadians Act, we had a number of different definitions for what a label was, or even inspection standards, and what we could expect when an inspector shows up. Under the Food and Drugs Act, a CFIA officer is effectively a Mountie, a member of the Royal Mounted Police, effectively in terms of powers. Under other legislation, they do not have the same powers. They're much more restrained. And so by placing definitions all together and alongside each other, it's easier for us to understand what our expectations are in terms of what a label is. Is a label something that's on a product? Is a label a website? Is a label something that's a tag affixed to something? These were all questions that we had under the previous framework, and now those are sorted out. We're working with one set of expectations in terms of what an inspection is, in terms of how these rules are enforced, and in terms of what the interpretation of these things are. And so in a lot of ways, it's really positive for industry. But there's no joke here. This is a significant obligation in terms of your Canadian and domestic players. Lastly, I'll say, and this is very fashionable around the world, frankly, there has been an addition of the concept of administrative monetary penalties, which are effectively monetary fines for those who break the rules. And so historically, if you were found to have contravened a part of the Food and Drugs Act, there were significant penalties, but they were done on a quasi-criminal standard. These were regulatory charges. You have to see things out to that beyond a reasonable doubt standard that the common law world is so known for. And that's really hard to do. Under the Safe Food for Canadians Act, the legislators built in something called administrative monetary penalties, which are set out on a civil standard, and they don't allow for a due diligence defense, which is to say that normally in a criminal trial, you can say, look, this thing happened, but I did everything I could to prevent it, and that gives you some protection under constitutional law. In this context, those things are taken away from you. So It's much easier, let's say, for the regulator to slap some administrative monetary penalties on a transgressor of the Safe Food for Canadians Act, which allows CFIA to collect a buck and also to try and drill home why you shouldn't break the rules without having to get the Crown or sort of the public prosecutor involved and having to go through an actual quasi-criminal process. So that's something to be aware of. Now, I mean, to date, CFIA hasn't elected to engage in many administrative monetary penalties under the Safe Food for Canadians Act. However, there are a few other acts they do oversee, including the Health of Animals Act and regulations, that do provide for AMPs, is what we call them, AMPs, and CFIA regularly does charge AMPs to those who are found to transgress that framework. Along this line, we've also built in new quality and safety standards. Some of these mirror what already existed under the Food and Drugs Act and are really not that big of a change except for how they are enforced, like through licensing. And so at a base level, it's important to ensure that food was made in a sanitary environment, that it's not putrid, that it's edible, that it's not contaminated, and that it's not mixed with another contaminated food. And so that's all restated in the Safe Food for Canadians Act. But suddenly, because it's a positive framework where you need a license, or typically you'll need a license, or your stakeholders who are down chain from you will need a license, it has a different impact now. And so being very clear about what it means to be putrid, filthy, or those sorts of things becomes a legal question, an important question to answer we really haven't figured out. And Canada, in its history, we've had maybe 5 or 6 reported cases on the definition of what it is to be a filthy or putrid food, for example, which is hard to sort of really pin down when there are very specific cases relating to fisheries in Newfoundland or a turkey farm in BC, or who knows. In order to address that, or in order to really sort of set standards, CFIA, under the Safe Food for Canadians Act and regulations, they have been able to create documents incorporated by reference. And in these documents, they've at times either created a set of standards themselves, which are not actually in the regulations. They're in documents that are incorporated by the regulations and can change more frequently. And sometimes they are the ones who are making the documents, and sometimes it's another agency. So sometimes it's Codex, sometimes it's a trade organization for beef production relating to how beef is graded, for example. And so there's some seeding. But I will say that unlike the previous sort of constellation, again, of regulations and acts that related to products like this, now we've got a vast number of pages of standards to which your ingredients are expected to comply with, and to which your products are intended to comply with, that can change on a more regular basis with less notice to you. And that's something to be aware of. It's something that as lawyers, I think we like to have some solidity in the law, and so we're becoming more comfortable with documents incorporated by reference as a legal concept, because, I mean, it's kind of like sticking Jell-O to a wall, right? Giving a legal opinion in one moment means that we've nailed it, but if those documents change, and then they will, and they do, without a whole lot of notice and without a legislative process, then suddenly our advice isn't worth what it was. So I think that those changes have been judicious so far, but something to track as folks who are stakeholders in international food, who do business in Canada. Something to be aware of is that this new framework does present an opportunity for our standards to be more of a moving target than they historically were. Now, ideally, what this means is that we have an easier time harmonizing these standards with other markets who are important. And so I think that assuming a good faith regulator, this is not a problem, but it's certainly something to be aware of. A concept that's built into the Safe Food for Canadian regulations is this idea of equivalency, which is kind of neat, in that there is an expectation that any country that has a regulatory framework where foods are produced and then imported into Canada should be roughly equivalent to it, to the Canadian framework. This obviously is, like, in a strict reading, impossible. Every country is different. Every country has its own sore points and has different ideas. And in Canada, we have I think a functional equivalency agreement with the United States, and we then just recognize a lot of countries for certain products as being not equivalent, but let's say audited, or something that Canada is comfortable with. So we don't see a lot of trouble with importation of food from most countries, unless it is a hot button item that comes up in our automated import reference system as prohibited on entry. Canada, of course, has its own weird foibles. We're very protective as a country when it comes to dairy and poultry, so chicken and turkey. And those are really closed off markets, except for the quota exception, which our European friends benefit from with CETA. All that to say, being functionally equivalent is really critical. In Europe, again, not going to be a major issue, but around the world, it can be a problem. There are exemptions for products that are going to receive further processing in Canada that are listed on a schedule that include things like cocoa, which would be difficult to do given where cocoa production typically happens in the world. Coffee, similarly, grains and pulses, those sorts of things. And so those are exempt, but generally speaking, we are, or at least the CFIA is seeking something that is roughly equivalent, or at least as protective as Canada is. It's a pretty high bar. So a question for all of our international food stakeholder friends, after all of this scaremongering about the Safe Food for Canadians Act and regulations, is, well, what can I do about it? And I guess there are two answers. Right now, there is really simply being accepting when dealing with your Canadian counterparts and the documentary requests that they are seeking, because they're for regulatory purposes, and the CFIA has a new set of powers. They can really ask for quite considerable documentation, and so humoring those requests where possible is really meaningful in ensuring the quick treatment of your good from a regulatory perspective. So if things are being detained for whatever reason, being more forthcoming about formulas, about being more forthcoming with, again, production information, ingredients, those sorts of things, that will save everyone a lot of hassle. CFIA generally has very good track record when it comes to preserving information. Canada does have a very expansive access to information regime, which means that everything that you share with a regulator can be shared if requested by anyone, a member of the public, et cetera. But there are certain exemptions that are taken quite seriously, including technical information, scientific information, commercial information, or information that might cause harm if it's provided by a third party. So when we provide information to CFIA, we have a pretty good idea of when something might be sent in confidence and would be exempt from an access to information request versus when it just comes forth. The second thing is, while none of our international stakeholders are required to be licensed under the Safe Food for Canadians Act, there is something called the non-resident importer program. And non-resident importers can become licensed under the Safe Food for Canadians Act in an effort to make the border process more straightforward and to ensure that there is harmonization between different jurisdictions. It's not quite like the foreign supplier verification program that we do see in the US, which has been a bit of a hit there, but it is comparable. It has been slow to be rolled out, and as I understand it right now, it only applies to importers from the United States. And as Canada adds to areas that are harmonized or functionally equivalent to Canada's food safety system, then more countries will be added to that list. And so for our European friends, we'd say there's more to come there, but there may be a way to sort of shortcut the red tape and some of this discussion in sharing information and so forth. When you have your own preventative control plan per Canadian standards, it may be easier to evidence for the CFIA that your food is made in a safe manner, for example. But more to come on that. That's been a file that's been slow to get moving, and now is just really, we're still seeing it being put into motion. So hang tight. So something new that I wanted to speak with you about this year is Canada's terrestrial animal and animal byproduct policy framework, which has been developed over the last several years and has become an issue in some of the files that we work on. Initially, terrestrial animal and animal byproducts, I think, were intended to relate solely to products that wouldn't necessarily end up in food, but could be an issue for foot and mouth disease, hoof and mouth disease, like these sorts of problems. The way the policies are being drafted, they're starting to inform how the health of animals regulations are being understood. What that means for foreign importers or manufacturers of food is that more and more information is going to be sought at the border in relation to certain ingredients that may contain prions or hoof and mouth disease or those sorts of things. And so what we're seeing is in an increasingly complex supply chain, when dairy is being sourced from a country and then produced into a second generation ingredient in another country and then finished in Valencia and then exported to Canada, is there may be an interest from CBSA and CFIA, our agency for food inspection, to have zoosanitary certificates or indications from either the country or the veterinarian that oversees the plant that things are done in a way that prevents the possibility, or at least limits the possibility, of those prions or diseases existing at that plant. This is becoming something that we didn't used to see, but now with this developing terrestrial animal and animal byproduct framework, we're seeing more discussions over what it applies to and what it doesn't apply to. And for us, when we advise our clients, we like to do so with a healthy degree of caution and skepticism, and that usually means seeking out some of this documentation on the chance that it's going to be sought for. But that's important to know for our European friends, because a lot of the products that are sent to Canada from Europe do involve a degree of butter or some dairy product built into a prepackaged product. And to have a pause at the border on the basis of this framework would be unfortunate and is avoidable. Packaging, nutrition, labeling. This is exciting stuff. Really 4 things we want to cover here. The first is we are updating and changing our food labeling as it relates to nutrition. This includes a variety of things that we'll get into in just one moment. Initially, it was slated to come into force December 2021. Due to COVID, we got a year's grace. Kind of nice for everyone to get compliant. We're seeing a lot of products in the marketplace that are struggling to understand the new rules. And make no mistake, the rules have, although they've been legislated for about 5 years, they've taken some time to get additional guidance on what they mean. And we've seen some changes to the regulations that were put in 5 years ago to try and help industry ensure that they can comply with this. So if you've already done your labeling compliance piece, say 3 or 4 years ago, it may be worthwhile to have those labels reviewed and make sure that they comply with the most recent sort of setup for food labeling. I know that manufacturers are buying packaging in increasingly large swaths, and so when you're buying a year or two's worth of packaging, just to make sure that things are compliant before you go to press or to go to print these things is certainly something that we would want for you. And so something to be aware of is that. We'll get into that in a greater detail in a moment. Next piece, front of packaging labeling is coming to Canada for certain products. We'll talk about that. Supplemented foods are going through a change. The framework has been rigid for a very long time, and after about 10 years, we're going to see some changes in the near future. There's a consultation about that that's just closing effectively now. And then lastly, single-use plastics rules are coming in. This doesn't really affect prepackaged food manufacturers who are accessing the Canadian market, but certainly for how food is brought to the market and consumed, it has a vast impact. So something to be aware of, we'll talk about in a moment. I've been frustrated over the years in trying to find a rhythm to some of these changes that are being proposed in Canada, and it feels like health policy folks and food policy folks and trade folks and our food safety folks and our enforcement bodies really haven't synced up their regimes. Great news for our international partners is that Canada is adopting a 2-year framework where every 2 years they will implement changes, and if changes aren't implemented by a 2-year deadline, then they'll have to wait for another 2 years, which means that you should be able to buy that packaging or make your plans for the Canadian market 2 years at a time, which is really helpful, as opposed to dealing with things that are coming in 2021 and 2022 and 2023, and then maybe off into the future. This gives you a lot more certainty. Okay, so nutrition labeling, big changes. I don't want to spend a lot of time on this. You can check last year's video. I think we spent more time on it. Primary pieces, ingredients now have sugars groupings. The ingredients themselves need to show up in a box or a different shading. The separators need to be bullets or commas. They need to be roughly in lowercase, typically in a Helvetica style font, and look quite normalized. Really sort of like leaning on what we've learned through the US experiment. Our nutrition facts table has changed as well. Lo and behold, very few foods actually have any vitamin A in them. So we've ditched vitamin A, vitamin C, from our minerals and nutrients section. We've replaced them with potassium, calcium, and iron. Calcium and iron were there previously. An emphasis on calories and some stylistic changes. This is all very, very technical stuff, and so for you, the takeaway here is simply, if you haven't had a checkup on your labels for food that goes to Canada in the last 5 years, I cannot encourage you enough to save yourselves some headaches and go and seek some help to do a label review and to assess your claims and to review your nutrition facts table, because someone's Safe Food for Canadians license suddenly kind of depends on it. So that's an important piece. Front of packaging labeling has happened in a variety of places already. It's coming to Canada. There seems to be evidence that this works or is helpful for consumers. The threshold that Canada is working with is 15%. So generally speaking, if a prepackaged product has 15% sodium, sugar, or saturated fats, then we've crossed that threshold, and you'll need to have one of these 4 lovely front of package label warnings on your food. We don't have a timeline for when this is coming in. This sort of got caught up in COVID. We were going full steam ahead on this, and I gave some presentations early last year on the incoming front of package labeling changes, and since then things have slowed down quite a bit. So something to keep an eye on. Certainly there are questions in industry's mind, and certainly in our mind, over what does this necessarily apply to. Does it apply to things that are more likely to be consumed as meals or as snacks, things that are natively high in sodium? Some things are exempt, some things aren't. And so we're really just waiting to see the true regulations as they're published in the Canada Gazette. But all that to say, it's important just to stay tuned and be aware that this is something that's coming our way. Now, I mean, I'm sure you're all experienced now with the voluntary framework in the US and the Mexican framework and what we've seen with Nutri-Score and things that have been proposed in Europe and in the UK. But in Canada, we will have a made in Canada solution that will just be slightly enough of a difference from every other jurisdiction to make you have to really check the rules and sort of bear with the process. Anyway, hang tight, that's coming our way. Big news for us this year is a change to the supplemented and fortified food framework in Canada. And I shouldn't say change, but proposed change. We're doing a consultation in Canada over how we decide what foods are supplemented, when, by how much, and what the process should be. This should be really welcome to most manufacturers who do engage in foods that are classically enriched. In Canada, obviously, like our dairy products are often enriched. Our flour fortification has been a very difficult and challenging process for a lot of our food trading partners. And then caffeinated energy drinks has been enriching beverages for the better part of 15 or 20 years now, and they've been living within something called a temporary marketing authorization letter application process. This process effectively says that we have the food and drug regs and we've got additives that you can use, and if you wish to market a food that doesn't comply with those food additive regulations, that doesn't exist within the limits set out on one of our lists of permitted food additives in Canada, you can write to the minister and you can ask the minister to give you an exemption and give you a temporary marketing authorization to bring a product that doesn't comply with any of these standards to the market. And the basis for that, historically, in the way that it currently exists, is on the basis of research, market research. How will the market respond to a caffeinated energy drink? How will this brand be responded to? What if it's this color? What if it has taurine in it? What if it has guarana? What if it's got slightly different marketing claims? Now, practically speaking, this trial process, this temporary marketing authorization for the purpose of research is it's a bit of a canard in that really our Red Bulls and our Monsters and every other energy drink that has a temporary marketing authorization tied to it is really seeking to access the market, just like every other market in the world. And it really isn't, let's say, about the research anymore. This change to supplemented foods and the supplemented food framework is really there to address that issue. And it's to try and take this process away from one of putting together a research proposal and moving it to something that is more normalized. Keep in mind that our regulations on enrichment are incredibly strict, and even very normal, usual products that should be enriched, if they don't fall within a specific standard, cannot be enriched, or the ingredients need to be enriched, and the process of getting a temporary marketing authorization takes an extraordinary amount of time and details from your suppliers and undertakings in terms of making the regulator aware if there's an adverse effect report, and they have timelines and significant capital costs to them. And so any change to that would be really helpful. I encourage you, and we'll have the link here for you to review, but if you do sell supplemented or fortified foods, this proposal is a big deal for you in terms of your ability to access the Canadian market. And so I encourage you to have a look at it. I can't give you specifics in terms of what's going to happen. I can't stare into the future, but this is an exciting proposal, and we seem to be dealing with a fairly mature proposal from Health Canada, and that's something that should be really exciting for any entity that is seeking to market enriched foods or supplemented foods in Canada. Just very briefly, I do want to talk about single-use plastics. As I said earlier, this won't affect most of you, but in Canada we have brought in an amended Schedule 1 to the Canada Environmental Protection Act, which relates to single-use plastics. Now, for most foods, this won't be an issue, but it does include standardized container sizes for many ready-to-eat meats and sliced bacon. And so depending on if you're bringing in certain types of meats that are ready to eat, that are ready to go, and we think in Canada, there are certainly lots of pre-sliced meats, cured meats, and pottages that may apply to this. It will be worth your time to investigate, to ensure that your products are compliant with that Schedule 1 and the container sizes that come in. No longer can they just be what it happens to be, or the equivalent in grams from the US pounds, but will need to be prescribed. So certainly an issue worth spotting if you're selling ready-to-eat meat products, bacon, like those sorts of things. Something to bring to your attention is our food additive system in Canada. This is something that trips up a lot of really smart regulatory folks internationally. In Canada, we have the Food and Drug Regulations. They still have something called Division 16, which contains all of our food additives and all of their accepted uses. But those are superseded now with a series of lists called lists of permitted food additives. And those lists actually supersede everything that's in the Food and Drugs Act and regulations, but really Division 16 in the regulations. And they're being updated regularly. There is a process for submitting new uses or new additives, which is being done regularly, which is helpful. But just if you are seeking to ensure that the composition of a product is correct, a really weird problem that we have that hasn't been resolved yet with food and composition is that the additive lists are the ones that you want to pay attention to. The Food and Drug Regulations, Division 16, is no longer of effect and nobody cares. It's something that confuses folks all the time. It's confusing. One day a government will get around to repealing, I suppose, Division 16 from the record, but just hang tight. And if you've encountered this problem, that's your answer. You want the lists. Just to run back really quickly to the discussion around fortification and enrichment, something that is also important for you to know in terms of composition. If you are selling a prepackaged product and that prepackaged product includes white flour, Canada has its own homebrew standard for flour enrichment in Canada that is inescapable, even if it's the most minute amount of flour in a product simply to be used to create a base. The expectation is that we'll have iron and certain B vitamins set to the standard. And there's no quarter for anyone who fails to meet that. That being said, we're uncertain in terms of how regularly it's enforced, but every discussion that we have with CFIA suggests to us that that is actively being monitored and is an important standard to adhere to. Similarly, Canada has been reviewing its plant-based proteins and simulated meat guidelines over the last year, which has been fascinating. Canada in the 1980s, the mid-1980s, created updated food regulations for simulated meat and you described the meat. And the requirement was effectively that the simulated meat needed to have the same vitamins and nutrients that the actual meat product would have. The policy worry at that time being that if people are eating, simulated turkey, that it doesn't contain iron or other nutrients that folks would be seeking. And so the government decided, it's like, all right, well, look, you need to fortify these products to make sure that they're like for like, at least on a macro basis. And that was all well and good until we got into the last, say, 5 years or so, where we have seen an explosion in plant-based protein products that are seeking to be similar to or relate to pre-existing meat products, which forcibly places them into this simulated category and then suddenly requires of all of those products to be enriched to the specific standards set out in the regulations. This is something that Health Canada and CFI are trying to figure out how to deal with the consumer who understands that what a veggie burger is versus what a real burger is to figure out how to deal with that problem. And maybe 30 years ago, the concern would have been that someone would go to the grocery store and go in for very nutrient-dense red meat and come back with less nutrient-dense slurry of some form, and that their family would be running on a nutritional deficit based on the way the product was marketed. Now that seems to be less of a concern, but it's still a worry. And so in Canada, we're looking at how to understand whether something is simulated or not, and when a veggie product is intended to actually replace a meat-based product, and then whether there's a third category where something that is identifiably plant-based has grains or seeds in it, or is very just evidently and clearly different than an existing class of meat product, how that can be marketed and whether that should be captured under the same framework. It's a really challenging time. We've spent a lot of time writing opinions on various products, and the ability to market them and how to market them in Canada so that they either do or do not get caught up into this framework, and how to manage that issue, as well as with traditional producers of protein products that are seeking to ensure that their products are treated fairly and marketed fairly and are not easily confused or replaced by non-meat products, which is really challenging. I don't envy Health Canada and CFIA's job in trying to figure this out. We know in Europe there have been very cantankerous debates in Brussels with members of European Parliament and very close votes on whether a burger can be a burger. But in Canada, we're having those same discussions in a very Canadian way, which is to say, we've got very senior bureaucrats trying to get a sense of the market, talking to industry, talking to new industry, and sort this out. Something that we do expect to see over the next 2 or 3 years as part of the forward regulatory plan of CFIA is increased scrutiny over the marketing of food products to children. Now in Canada, Quebec has been notorious for having really aggressive or overarching prohibitions on the marketing of products to children generally. It was way ahead of its time in a lot of ways, and in the 1980s, there are sort of our seminal freedom of expression cases come from this law. At this point in time, what CFIA is starting to think is that industry has too much latitude to market foods to children, particularly those that are high in those same front of package labeling macros, so saturated fat, sugars, and sodiums. And so something that you can expect in the near future is more information on how they intend to bring that into law or into force. At this stage, it's simply in consideration mode. It's in a larger plan. We haven't seen regulatory action or regulatory change on this, but again, please stay tuned. The last thing I wanted to speak with you about is a brief update on the EU-Canada trade agreement for free trade. This has been incredibly impactful for access to the Canadian market of European food products, particularly in relation to dairy. This past year was difficult. A lot of my clients found it was difficult to get quota, but there's still some real stabilization and opportunity there year in, year out for cheese manufacturers. Likewise, and again, the update in a lot of ways is, like a lot of this talk, looking forward to pieces. And so in looking forward, it seems that we're going to have more harmonization and an easier time at the border. If you are having trouble accessing the Canadian market, trying to find a way to bring your products into Canada, the Global Trade Canada and these trade supports can be profoundly helpful, often in terms of finding a trading partner, finding someone who's reliable, or navigating an issue. Generally speaking, Canada really values its role as a member of the international marketplace, let's call it. And so these supports are there typically for Canadian businesses, but they relate to foreign-made products that are destined for Canada. And those are really important supports to help bring foods into Canada. So if you're facing an issue, it's non-legal in nature, or maybe you're trying to sort something out, or you're looking for some supports, a way to link up with another processor in Canada, or you're trying to deal with a tariff issue, or who knows, often that's a good place to pick up the phone and attempt to speak to someone to navigate that. So it's been an absolute pleasure speaking with you today. Thanks for listening and watching. And if you have any questions or you'd like to meet or reach out, please send me an email. I'm happy to chat. We do work with everything from small domestic, small and medium-sized enterprises all the way to very large international entities that are seeking to domesticate products in Canada. And if we're not the fit for who you need, our network is really quite deep in Canada. And so we would be happy to help you find a home for whatever legal needs that you have. Other than that, thanks again for listening. It's been a pleasure. Take care.